You're about to have your deposition taken. You'll be asked a number of questions under oath by an attorney. Detailed questions about yourself and the case you're involved with. These questions and your answers will be recorded and transcribed by a court reporter. The result will be a written document containing word for word all the questions asked with the answers that you gave. A document that ultimately may be entered as evidence in a court of law. This program will help guide you through this somewhat intimidating legal process. We'll explain why a deposition is taken and show you how to avoid mistakes that witnesses commonly make. Your goal should be to give the best testimony you can, which may ultimately lead to a just resolution of the lawsuit. As you watch, you might have additional questions about the process, what to expect or what to say. Jot these questions down so that you can discuss them later with your attorney, after you've viewed this tape. What's the purpose of the deposition and why is it so important? Well, the primary reason to conduct a deposition is what lawyers call discovery. Discovery is the legal term for the process of gathering all the facts and information that may pertain to a case. It's an attorney's professional responsibility to learn as much as he or she can about any matter handled for clients. A deposition is one of the many procedures used for this purpose. But there are other more subtle reasons for taking depositions. In addition to probing for leads and information that can help or harm their case, a questioning attorney uses the deposition to size you up, evaluate you as a witness to determine your credibility or believability, and to see how well you will present yourself in front of a judge or jury if you eventually are called to testify in court. Furthermore, during this fact-finding, the lawyer is asking you to commit to testimony under oath in the hopes that your answers may contain incorrect or inconsistent statements that can be used later at trial. Finally, it's important to understand that the deposition may well be the only time you ever testify in the case, because most lawsuits never go to trial. Despite the presentations of TV and the movies, more than 90% of all cases settle out of court. So, what you say and how you say it in your deposition are very important and may have an impact on the outcome of the case. If this all sounds a little intimidating, it needn't be. If you just follow the simple guidelines in this video and the instructions of your attorney, you'll do a great job. Your primary responsibility at the deposition is to listen carefully to each question, to make sure you understand the question, and then to answer the question truthfully and accurately. Does this mean you have to know the answer to every single question? Not at all. Will you have to know and remember every fact about the case? Hardly. Should you always tell the truth? Absolutely. Depositions usually take place in a conference room at a law office, hotel, or some other neutral site. At the deposition, there will be at least 3 other people present. First, your own attorney, who's there to make sure that your rights are protected and that you understand everything that takes place. Second, the opposing attorney. This attorney will ask questions in an effort to learn as much as he or she can about the case for the benefit of his or her client. Third, a court reporter. This individual will take down everything that is said on the record. It's also possible that support staff members for one or both attorneys will be present.
Would you please raise your right hand? Do you solemnly swear that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
With the taking of the oath, the deposition begins. You're now on the record, and anything said will be taken down by the court reporter. However, the court reporter cannot record nodding of the head, gestures, and other nonverbal communications, so you must answer each question verbally. Also, instead of saying uh-huh, say yes, and no instead of uh-uh.
Mrs. Douglas, my name is John Brennan. I'm representing Mr. Howard in this case. If at any time during this deposition I ask a question that you don't understand, please let me know and I'll try to rephrase it. If you answer the question, I'll assume you understand it. Now, state your complete name for the record, please.
Susan Douglas. Susan Mary Douglas.
Are you married, Mrs. Douglas?
Yes, Bob and I have been together for 15 years. 14. It'll be 15 next month.
Do you have any children?
Yes, I have 3.
And what are their ages?
Bobby's 10, and I have 2 daughters. Tracy's 2, and Lynn is 7. No, that's 8 and 2. No, I'm sorry, not yet. One is 7, and the other's almost 2.
Do your best to stay calm. Take your time when answering the question so you don't quickly give the information that you're unsure about, then have to correct yourself. Remember that the result of your testimony is a written document. Pauses will not show up on the transcript. Susan Douglas's case involves a car accident at an intersection. She's suing defendant Reed Howard to compensate for injuries she received when Howard ran a stop sign and collided with a car that crashed into the car she was driving. Even though Mr. Howard was the major cause of the accident, his attorney would like to show that Mrs. Douglas was partially responsible for the accident by either driving too fast or failing to stop once Howard entered the intersection. While the facts of your case will be different, the techniques you'll see demonstrated will be useful in giving effective testimony. Now, let's look at some guidelines for your deposition. In this example, Mrs. Douglas gives the opposing attorney an advantage by volunteering information that goes beyond the scope of the question.
How long were you driving on Capitol Avenue before the accident?
For probably about 6 blocks, because I turned left on Capitol from 3rd. Yes, that's right. The doctor's office is on Capitol on 3rd.
Oh, you were at the doctor's office that morning?
Yes, that's where we were coming from.
When you say we, who were you talking about?
My 2-year-old daughter, Tracy, and my son.
Why were you at the doctor's office?
I had been up all night with my daughter, Tracy. The doctor thought that she probably had strep throat.
In her answers, Mrs. Douglas has gone beyond the scope of the questions, a common error. She's volunteered unrequested information and has given the opposing attorney new leads of inquiry which could damage her case. For example, was she distracted by her sick 2-year-old? Or was she inattentive because of a lack of sleep? That's all it may take for a judge or jury to form an opinion or to draw their own conclusions about the cause of the accident and to possibly weaken her case. Many of us want to be helpful or want to tell our side of the story, but in a deposition, it's unwise to volunteer information of any kind. Here are a couple of easy tips to avoid this common mistake. First, remember to listen carefully to each question asked. Then, limit your answer to that question. When you've provided the information asked for, stop and wait for the next question. Don't let nonverbal cues like raised eyebrows, silence, or a tilted head from the opposing attorney coax you into talking more. One technique to stay focused on the question is to use part of the question in your answer. Let's see how Mrs. Douglas might have answered differently.
How long had you been driving on Capitol Avenue before the accident?
Let's see. For about as long as it takes to go 6 blocks. I was driving on Capitol for about 45 seconds.
Here, Mrs. Douglas thought about her response before she answered. Her answer was brief and to the point. Another simple rule to keep in mind is to be certain that you understand the question. A witness should never try to answer a question unless its meaning is absolutely clear. Questions are sometimes ambiguous and vague because language is not very precise and words have different meanings to different people. Also, lawyers have a reputation of using phrases and terms not typically used by others. Let's see an example.
While you were driving on a preferential road, Mrs. Douglas, you didn't happen to see whether Mr. Howard was going to stop or not, did you?
Yes. I mean, no. No.
Obviously, Mrs. Douglas doesn't know the legal meaning of the word preferential. Let's look at that question.
While you were driving on a preferential road, Mrs. Douglas, you didn't happen to see whether Mr. Howard was going to stop or not, did you?
No matter how she answers this, yes or no, it will be unclear whether she's saying she was looking out or not, or whether she saw that Howard would or would not stop. Don't be afraid to ask what a word or question means. And if you don't understand a question, ask for it to be repeated, clarified, or put in plain language.
What do you mean by preferential road?
A major thoroughfare.
Oh, and can you repeat the question? I don't think I have it clearly.
I agree, Counselor. The question is ambiguous.
Another problem area is guessing at the facts. When a deponent begins to guess or tries to answer when they're really unsure, they're asking for trouble. Just because a question is asked doesn't mean you have to know the answer. This is especially true when discussing detailed issues of time intervals, distances, and speed, such as in this example.
Mrs. Douglas, how far were you from the intersection when you noticed the Howard vehicle?
I was maybe 20 yards away.
And how fast were you going?
I was going the speed limit, 35 miles an hour.
How much time elapsed between the time you saw the Howard vehicle and the impact?
Oh, let's see. That's hard to say.
Well, was it about a minute? Surely you could tell me that.
Well, it was less than that.
Between 30 seconds and a minute?
No, less than that, I think.
Well, was it 10 seconds?
I suppose. I guess that sounds about right.
Mrs. Douglas seemed sure of her distance and speed, but really did not know how long it took her to get to the intersection after seeing Howard's truck. Her mistake was in letting the lawyers suggest an answer by putting words in her mouth and forcing her to guess about the time. This has put her testimony about distance and speed in doubt because the numbers are not consistent. For example, if she was going 35 miles an hour and she really did have 10 seconds to react to Howard's vehicle, she would have had plenty of time to stop. So the judge or jury might conclude she wasn't paying attention. Be sure to review the facts of the case with your attorney so there's no confusion about what happened. And remember, if you don't know the answer to a question, or if you can't recall a fact, it's perfectly appropriate to say, I don't know, or I don't recall.
How much time elapsed between the time you first saw the Howard vehicle and the impact?
I'm not sure.
Well, was it about a minute? Surely you could tell me that.
No, I don't know.
Was it between 30 seconds and a minute?
All I can tell you is that I don't know.
In this last example, not only did Mrs. Douglas not guess at an answer, she also did not let the attorney suggest an answer. There are some other times when witnesses are tempted to guess at answers. One is when there's a question or reference made to information contained in written documents. If this happens, you should request a copy of the document in question to refresh your memory.
Mrs. Douglas, isn't it true in the statement you gave to the police at the time of the accident that's in the police report, you stated when asked how you were that you were fine?